For those of you who haven't met yet, my name is McKenna. I'm a faculty member at the law school and the director of the program here that Notre Dame Law School runs in the summer, which is an intensive intellectual property and technology law program. So for those of you who are guests here today, this event marks the end of the first week of that program. This is the third year that we've run it, and our students, we have 15 of them here this summer from various United States law schools and from Peking University in Beijing, China. Those students are taking 3 intensive IP or technology courses over the course of their 3 weeks here. Courses like Protecting Patents in a Global Economy, Comparative Privacy and Data Protection, Copyright in a Digital World, Arbitration of Intellectual Property Disputes, and Trademarks and Geographical Indication. So we're working them kind of hard, but also one of the things that we've always tried to do in running this program is to connect our students to the London legal community and to a variety of organizations and activity that'll help deepen the learning that they're from their classwork. And so this event, both the talks we're about to hear and the reception that follows, which I hope you'll stick around for, are all part of that effort. So thank you for coming. This year we're really fortunate to have the pleasure of hosting as our distinguished speaker the Right Honorable Professor Sir Robin Jacob. As you can guess from the length of that title, Sir Robin is a quite distinguished person. He is the Hugh Laddie Chair of Intellectual Property Law and the Director of the Institute of Brand and Innovation Law at University College London. He joined the UCL faculty in May of 2011 after his retirement from the Court of Appeal of England and Wales, on which he served from 2003 to 2011. I should say his formal retirement from the court, because I understand he still continues to sit from time to time.
No, my time expired.
Okay. All right, I take it back. Now no longer formal. Prior to his service on the Court of Appeal, Sir Robin served as a High Court judge in the Chancery Division. From 1997 to 2001, he was the supervising Chancery judge for Birmingham, Bristol, and Cardiff. Earlier in his career, Sir Robin served as Queen's Counsel and as Junior Counsel for the Comptroller of Patents and for all government departments in intellectual property. He's widely known as one of the world's leading experts in intellectual property, and particularly patent law, and he will talk today about the uncertain future of the Unitary patent. We're also really lucky to have with us Professor Rochelle Dreyfus, who's here teaching a course in the program on protecting patents in the global economy, and she will be offering a response and leading some discussion after Sir Robin's talk. Professor Dreyfus is the Pauline Newman Professor of Law and co-director of the Engelberg Center on Innovation Law and Policy at New York University School of Law. She's one of the world's leading experts on patent law, and particularly international and comparative patent law. Widely published in that area and on other IP topics, Professor Dreyfus is a member of the American Law Institute and served as a reporter for its intellectual property principles governing jurisdiction, choice of law, and transnational judgments in transnational disputes project. She's been a member of the National Academy's Committee on Science, Technology, and Law, and a number of other national committees, and we're very fortunate to have both of them here. So I'll turn the podium over now to the Right Honorable Sir Robin Jacob. Thank you.
Good afternoon. I expect most of you would rather be doing something else on a nice warm summer evening, but we're here, and I'm going to tell you about this extraordinary project of Europe's. It goes back a very long way. I was told by a patent office official that he had seen in Nazi archives a project for a European patent and a European patent court. There were to be 3 languages: German, French, and Italian. The first sort of public record of the idea of this court is in 1949, well before the European Union or the EEC. At the very beginning of modern Europe almost, at the Council of Europe, which is not an EU organization. In Europe it is so complicated. Some things are EU, some things are wider than the EU. And the Council of Europe is wider. And there was a proposal there to create a patent court and system. Nothing happened. The next stage was something about substantive law, and a small committee of people whose names I do not know, 6 of them, I do know there were 6 of them, produced draft substantive law for Europe. And it is that substantive law which got in something called the Strasbourg Treaty, 1963, which actually is the substantive law we now have in Europe, and I think is probably the best statute on substantive law of patents in the world. way ahead of the American one. Still nothing happened. And then the idea came to create a convention which embodied the substantive law as an international convention, not a European Union, not EEC, an international convention. And it came in the end in 1972, but they couldn't create a court. They did half the job. They said, we'll have a patent office, and we'll make everybody line up their laws, and this patent office, we can't abolish all the national ones, so we'll have everybody will have two patent offices they can go to. They can either go to their national patent office, or they can go to the European Patent Office. And you could go to a bunch of national patent offices, you still can. Some people are thinking of doing just that to avoid this court. But the European Patent Office was founded, and the plan there is that you apply to the Patent Office, and when they've processed it, which is a process between you and the Patent Office, a patent is granted, but it's not really a patent, it's a bunch of sister patents. They take effect in each national country as though it had been granted by the National Patent Office. And meanwhile, the national country hasn't brought its law, its legislation, in line with the requirement of the EPC, which was the Strasbourg law. But they were still separate courts. You still had national patents, a French patent, European patent, FR, European patent D, European patent UK. So you now had identical worded patents, basically, with separate jurisdiction over each country. It could be found valid in one country and invalid in the other, infringed in one country, not infringed in another. Didn't look very tidy. But the European Patent Office was a huge success, if you go by numbers. It did it did have a little system of something called opposition, which wasn't really honestly named. If you don't like the patent that's been granted, you can go there within 9 months and say it's no good and knock it out centrally. They call it opposition, but it's been granted, so you're really applying to revoke. No question of any kind of standing to do that. And I don't think there's any question of requirement of standing to attack a patent anywhere in Europe. You can be a straw man. Just say, I think this patent's no good, I'm going to apply to knock it out. Very few people, in fact, I don't think anybody does it vexatiously. It's not very cost effective because unlike the United States, if you do that in a national court and you lose, you get to pay the legal costs. Well, the European Patent Office started creating a European Patent Judges Symposium. Started in 1982. And it ran every 2 years. Of all the patent judges, not all of them really were patent judges, and they met in a different European capital every 2 years. And I got mixed up when I started being a High Court judge, when the UK was the host, and we went to Wales. It was a strange meeting in some ways. I was a bit suspicious of these European judges. They were probably rather more suspicious of me. The British judges who had gone there before had gone and said nothing till Mr. Justice Alders just before me. The others had just gone there and sat there. But this time I was there, and shortly afterwards Hugh Laddie came the next one. And we got talking to these European judges, and we thought it was damn silly having all these different courts deciding on the same patent. And in 1998, the president of the Federal Court of Germany, that's the patent court, said, why don't we form a group of people, we call it the Madrid group, because that's where the conference was, to start pushing for a European patent court. It was joined shortly afterwards by industry, who said, yeah, that's a good idea. And the plan was not like the current system. The plan was something called the European Patent Litigation Protocol. And the idea was a very naive, perhaps. We thought, well, every country that wants to join just joins, and we all pool the judges, and it's one court for every country that joins. It would have its own rules, but that was it. We didn't think it had anything to do with European Union law. We were probably right about that. But the plan got quite advanced, and then it was stopped by various political ideas. So then the Commission got involved. And the plan for some was that this would be a European Union court. But that was a non-starter, really, because the Court of Justice had already made some impression in intellectual property, and that impression was not a good impression. It remains not a good impression. And industry said, we are not trusting our patents to that court. So you couldn't get political backing for it. So the scheme morphed, and the details don't really matter, but it morphed into a system whereby there is an international court. There were challenges to it, particularly a Spanish challenge, and everybody thought the result of the court's decision of the Spanish challenge was that you had to be a member of the European Union. It didn't actually say that. What it said was that the court would have to accept European Union law insofar as it applies to patents. Well, it doesn't much. There is something called the Biotech Directive, probably an illegitimate document, because substantive patent law, and it deals with substantive patent law, is a matter for the international treaty, which has got 38 member states. There is a directive about enforcement. There will be rules about jurisdiction, and possibly defences such as competition law defences. But that's not the bread and butter. None of these things are the bread and butter of patent litigation. The bread and butter of patent litigation is scope of patent protection and validity. These other subjects are occasional. So after much discussion, they came up with a scheme. To my mind, a mistaken scheme of having divisions. Divisions means two things. One is a sort of local presence, and I'm not against that. But the other word of division means division. And if you start having different parts of an area with different patent courts, you get forum shopping. You get the Eastern District of Texas. And, of course, people fear there might be an Eastern District of Europe in some division. So we've got divisions. Germany's got 4. I think that's too many. It's all done on the basis of how many patent cases you have every year. Nobody knows how you count the patent cases. Germany counted at least twice for many cases, but sometimes 3 times, because if you start a patent action in Germany, it goes to one of the state courts, and they only deal with the question of infringement. If you want to attack the patent, you go to the Federal Patent Court in a separate proceeding. That's 2 cases. Of course, if you want to sue on several patents, each one of the patents counts as a separate case. Here, you can put 6 patents into one case, and the validity will come free as well. So Germany's got more than it should have, I think. All the other countries who are interested in having a division will have 1, except in Scandinavia, where 3 of the, Sweden and the Baltic states and Finland are willing to have a regional division. The Danes said, no way, there will be a little Danish division. And it's quite a complicated setup, but actually it's not bad. One of the requirements is that the court actually knows something about patent law. That would be quite a good requirement for Supreme Courts around the world. They've all got some sort of disease about patents at the moment. Our lot seem to have gone so pro-patenty it's hardly possible to believe. The United States go anti-patenty, it's hardly possible to believe, and the Australians are way up there too. Canada has pulled itself back in line. The statute, and there is a statute for this international court, says you've got to be experienced in patent law. That's a bit of a problem for Europe, because some countries don't do any patent law. There isn't much patent litigation in Slovenia. So the statute goes on to say you can get it by training, and there will be a training centre, and there is one in Budapest. And people have been on training courses. And apparently they were very successful. They had to do an exam at the end. They heard a mock trial and had to write a judgment. Their judgment got marked by experienced patent judges, and they reckon they were surprisingly good. So that's a good sign. If the division doesn't have too many cases, or the country doesn't have too many cases at the moment, then you have to have 2 foreign judges. If it has enough cases, then you have 1 foreign judge. Well, these divisions are coming into being. There's going to be one in Paris. It's going to be on the Ile de la Cité in the great very old-fashioned law courts of Paris. You can see the chamber where Marie Antoinette was condemned. They're not a very good building, actually. There are no rooms for judges. One French judge said to me, she says, all I have is an hook. I said, what? An hook. She meant hook for her coat. No desk even. But they've got some associated rooms nearby, and they're planning to make it bigger, and they're moving a lot of courts out to, all the civil courts are moving out to some suburb of Paris. Germany's got local divisions. We have yet another division to talk about, the central division. The UK has got the best of all the court buildings, and it exists. It's on the east side of London, east side of the city of London, and it's big. It's got 4 courtrooms, 4 big courtrooms, and of course small rooms could also be used. It's got the whole of the 3rd floor of a new tower block. Now the central division. During the negotiations, the Germans kept saying, we want bifurcation. Separate trial of infringement and validity. I don't think they were stood up to enough. Because it really was one of the reasons why they wanted local divisions. I didn't want any divisions. I wanted all the judges to be in a central pool. You find out who's doing the case, what the case is about, where the parties are, what language they want to speak, or languages, and you fix the court around it. But this division business will be a bit difficult, although there may be ways round, such as appointing all the judges to all divisions. But because the Germans wanted bifurcation, there was the idea of a central court, emulating kind of the German Federal Patent Court. So there is a central division. There was a huge fight about where that's going to be, and the fight resulted in a bit of a draw. Headquarters in Paris, but divisions in London and Munich. Allocation of case depending on the classification of the patent in the International Patent Classification System. This may be very inconvenient at times when you have two patents, one of which is in one classification, one is the other, but they're really rather related. A medical device and some substance which is used with the device might end up in different divisions. Some countries are not going to bother with having a local division. They have to pay for it. And they're going to cede jurisdiction to the central division. And two of the countries are Luxembourg and Malta. So lawyers may play a game. For example, if Unilever start bringing some product onto the market, Unilever may say, well, a plaintiff who wants to sue them may say, well, you, Unilever, sell all across Europe. So you're planning to sell inter alia in Luxembourg and Malta. So I sue you in Central for threatened infringement in Luxembourg and Malta. There's lots of games for lawyers to play here. There is, of course, the problem of language. Everybody knows that in the real world, 90% of this work is going to be in English, at least. It's obvious, really. You only have to think about it. Most of the litigants will not be Europeans. No patent court has a majority of people from its own country except China. So you get Japanese fighting Koreans in courts around the world. You only have to look at the cases coming out of Germany or anywhere, and you'll see that lots and lots of them are foreigners. And this is going to be a big court, so it's going to be a court for foreigners. What language will they want? Well, the United Americans will want it, English. What will the Chinese want? They're not too strong on German or French, so they'll want it in English. What will the Japanese want? In English. And increasingly, very probably, we will see quite a lot of Chinese litigants, 10, 15, 20 years' time. So the court will actually work in English. But there are politicians' rules about having to issue proceedings in the local language of the local division and so on. That may stop people going to those divisions, because it'll delay everything. It'll cost more. We don't know yet. Let's talk a bit more about the judges themselves. As I said, quite a lot of the judges in Europe have got to know each other, particularly the UK, France, Germany, and Holland. But also some of the Scandinavian judges are particularly focused and know each other. Pretty well all of those people are applicants. I can't say who are and who aren't. I know who all the applicants are. The project people did something very stupid. They put out a general letter at one point saying, would you be interested in being a judge of this court? Either a technically qualified judge or a legally qualified judge, or both, one or the other. We got 1,300 replies. And a small team was created, of which I'm the chairman, of 7 of us from different countries. And we had to go through this lot. And in the end, we decided we couldn't use the results we had. They got letters saying, you think you look good, but there had to be a real application saying, not might you want to be a judge, but do you want to be a judge? This is an application form. This time we got it down to 840. There are 2 sorts of judge. I've already told you that the legally qualified judges have to be qualified in patent law. But the court has the possibility of having technically qualified judges. And these are largely going to be patent attorneys in part-time practice, which itself gives rise to problems potentially of conflict of interest, which are rather delicate and being looked at now. Is it okay for you to appear before the court one day and be a judge of the court the next? Is it okay if your firm does lots of cases before the court? Can you do any? Or have you got to step back? And is it good enough if you step back if your firm is doing it and you're still the part-time judge? Everybody fears you'll be talking to your partners about the propensities of the legal judges. Is it okay if you come from a firm which acts only for big pharma and deciding a pharma case where there is a generic company fighting big pharma? These are all difficult questions which we've got to work our way through. The court has a court of appeal. The politicians put it in Luxembourg. How many of you have been to Luxembourg? 3.
Good food.
It's a difficult place to get there. It's very good food. Difficult place to get to, difficult place to get back from. London's not so bad. There are flights direct. Most countries don't have them. It's an expedition. They should never have put it in Luxembourg. Where we've got to? Well, my team did its bit. We have picked the people to be interviewed by a system which was prescribed by the politicians, which says in effect that they've all got to be interviewed. Doesn't matter how eminent the judge, doesn't matter how obvious the candidate they are, how much it really matters that that candidate is there, they still have to be interviewed, and what's more, they want us to interview them in person, except in exceptional cases. We might break one or two of those rules quietly. Well, they want 50 judges legally qualified and 50 technically qualified to start with. They want another reserve group of the same number, 50 and 50, in case this court takes off and there won't be enough judges. And then they want some who don't get selected. So we've got to interview, we brought it down a bit, we've got to interview 230. There are 7 of us on the panel now. The plan is to increase that when the thing goes into something called provisional application. Interviews can't start until that happens. How near are we to that? Well, we thought we were going to be there in June. Brexit happened. But the British government, almost immediately afterwards, announced that it was going ahead with this project. They said, oh, the court's an international court, it's not a European Union court. They didn't deal with the problem of those little bits of European Union law which would have to go to the European Court of Justice. They're finding the same sort of thing with Euratom and the Medicines Agency. And there are bits I think we're stuck with, whether they like it or not. So that held it up a bit. There's also the question of the ratifications. This system cannot come into place until it is ratified by 13 countries, 3 of which are France, Germany, and UK. France ratified early. Not a very bright idea, really, because at that stage nobody knew the detail of what was actually they were ratifying. We only had the statute. We didn't do it, and the Germans are determined to be last. The current state of play is that we don't think we can we don't think we can go into. There's 2 stages. One is to go into provisional application, and there's actual ratification. We don't think we can go into provisional application or agree to it until it's one formal thing has gone through Parliament, which is the approval of the privilege and immunity orders about the position of judges. The judges can't be sued and so on and so forth. That was due to be debated in Parliament on Monday, but they never got to it. Meanwhile, there's been a challenge in Germany to the constitutionality of the whole approval that went through Parliament in Germany. We don't actually know the basis of that. That's a phenomenal fact, isn't it? Somebody's made an application to the Constitutional Court of Germany, and you cannot know who made the application or what their grounds were. There is not a document in sight. All we know is the President of the Constitutional Court rang up the President of Germany and says, please don't sign the legislation. I don't quite know whether it was an order or not, but anyway, they're not doing it. There are speculations as to what the grounds might be. And the best bet is that the chap is saying it has to have 2/3 of the Senate. And this thing was debated early in the morning after a very late night session. And there weren't 2/3 of the Senate there. I think there was nobody arguing against it. That's not the point. There weren't enough of them. I think that's one of the suggestions as to what the point is. There may be another one about the unconstitutionality of the European Patent Office, but that seems unlikely. So we don't know how long it's going to take. Nobody in Germany can tell you. And we don't know where we're going to go with our PAT provision. The expectations are that we'll still be on course for December. And if it's in December, we can start interviewing and probably get it done by March, and we could start it in the spring of next year. But it seems wholly improbable that this can be untouched by the Brexit negotiations. And indeed, Monsieur Barnier made such a comment saying, oh, well, the court won't be able to stay in London, and the Brits are out. It's quite gratifying that all the Continentals are deeply against the Brits being out. They say we really need the English judges. And to tell the truth, I think they do. Because it'll be part of the credibility of the court. Anyway, if it has to be redone, it would have to require a new treaty. Italy is looking at it. I've seen the rooms in Italy which they've reserved for just the Italian local division. There could be enough room there for the central division if it moved from London, the London branch to move to Italy. And I gather the mayor of Milan has been rubbing his hands. Will it come into force? I sort of think the betting is still yes. If we get this going this year, and it's happened, I think the chances of it being undone again by the time we leave the European Union are quite low. Somehow it'll be made to carry on. But you can't tell anything in politics these days, can you? I should say something about the procedures before the court and the costs. They have been extremely penny-pinching about the court. It's supposed to be self-funding, as though it was some kind of enterprise. This is a notion which has crept into our system. The Germans have done it for years. They're more than self-funding in some of the Länder in Germany. They make a lot of money out of it. And you're supposed to value the case, which is obviously a piece of complete fiction, because how much is a case worth? Well, that requires you to have a crystal ball. This patent is being litigated now. What's it going to be worth in 10 years' time? Is this injunction a big injunction, or is it completely pointless because there's something else to do instead? So you can't value it really. But nonetheless, they have a system in Germany, and we've all agreed that's what we're going to do. And there are court fees. And the court fees for counterclaims, and that's been a big argument. There's lots of arguments. I mean, why should I have to pay a court fee for a counterclaim when I'm just defending myself? At the moment, obviously the governments are having to fund it. There is a very complicated IT system. It has to copulate with 3 languages. Have they done something sensible like going to California and seeing how it works in California? No. They're inventing it all over again. But this is more complicated than the Californian one, by a long way. It's a very front-loaded system. There are detailed rules of procedure where basically you're going to have to put your whole case in at the very beginning, which is going to be quite hard for a defendant, because the defendant may not have much notice. The plaintiff can spend all the time he likes thinking of his case and getting it all ready to go. It's got very powerful procedural tools. We've been taking things from different legal systems, so it'll have a saisie system, as in France, where you can just start the case by going in and inspecting the defendant's factory and taking his documents and the like. Sort of a very advanced discovery of a compulsory nature. There are arguments about the court's jurisdiction over injunctions. There are fears that trolls will say, this is the place to litigate. We can litigate and get injunctions all over Europe. There's one big add-on about the system. What I've been describing so far is litigation of parallel sister European patents granted by the European Patent Office. You can put them all in one go, so if you've got 6 different patents in 6 different countries, you can get an injunction for all 6. But separately, there is a project to have a European Union patent, a unitary patent, which will give you protection all over. And the European Patent Office is very excited about it. Personally, I think it's unlikely that people will go for it very much. It will cost of the order of France, Germany, UK, and Holland. The costs of the sister patents increase the more countries you have. Well, not that many inventions are actually patented beyond those 4 countries. Some companies don't go that far. IBM, Germany, UK, and France, I think. BMW, Germany and UK. Why do they do that? Well, because if you can get an injunction in Germany, you can't sell a car in Europe, anywhere. So whether there'll be much take-up for this patent, this unitary patent, I do not know, and I rather doubt. You don't really need an injunction in Malta. Only pharma does. Now, pharma are very suspicious of the court, and there is a system of opting your patents out. You don't have to be in this system for the first 7 years, running on maybe to 15. And it's expected that pharma will probably opt out its patents, its major patents. They may leave some in. There is no opt-out fee at one point. There was a great worry about that. There was a thought they were going to try and raise money on the side by charging you €100 a patent you opted out. So pharma may not join the system, begin with. They may. There's still a completely unresolved question of how you deal with the European Patent Office opposition system in relation to this court. This court is supposed to work fast. The European Patent Office opposition system does not work fast. Indeed, it works so slowly that sometimes, not infrequently, the opposition is still going on when the patent expires. Perhaps because of this court, they're trying to tighten it all up. But speeding up by their ideas will still be a 6, 7, or 8 year program. And they often have decisions go from opposition division to appeal, back down again, back down, ping pong. So that's all unresolved. It's pretty unsatisfactory because you get a result from this court and then you get this European Patent Office perhaps revoking the patent or restricting its claims so the defendant no longer infringes. So all those things have not been sorted. The European Patent Office has cleaned up its act to some extent, and the boards of appeal particularly are going to do have in effect a kind of chief justice who's a real judge or was a judge in Sweden. But his task is not all that happy. And I saw him the other day, and he's feeling the heat a bit. Well, will it be better than the United States system? Some ways yes, some ways no. It has one great virtue, no jury. Second great virtue, judges who know something about patent law. Third great virtue, much cheaper. Won't have all this ludicrous discovery. Fourth great virtue, loser pays. Legal fees and court costs. That's not bad to start off with. I mean, everybody's got their patent systems. Their litigation systems are nearly always badly designed because by and large, in most countries, except for this European court, they are not designed for patents. They're designed as the litigation system generally. One thing I think will happen when this court's got going is you will get a fast decision. There is a real desire amongst the judges to make sure we get on with it. The statute lays down they're supposed to be within a year. Well, I don't suppose we'll get that far. And I think there will be a big difference. One of the requirements in the system is proportionality, so that you treat a big case differently from a small case. The court may order cross-examination, but it's likely to allow you 1 hour, not days, and probably won't order it unless the case is worth enough. But in the end, it has a real chance of being the best patent court in the world. That's probably enough for me at the moment.